Welcome to Asst College of Arts and Commerce. This is Asst Edupedia. Myself, Assistant Professor Sunil Shah. Today I would be covering up the topic called dispute settlement under the module 1 of the subject called industrial law, which is there in first year BMS of semester 2. Students, under the Industrial Dispute Act, settlement means and settlement arrived at in the course of conciliation proceedings and include a written agreement between the employer and the workman arrived at otherwise than in the course of conciliation proceedings where such agreement has been signed by the parties. What does it mean? That when there is a dispute between the employer and the employee, it may go into the court of law. In the court, there would be the person would be called as conciliator or the conciliation officer. He would be hearing the disputes which are being taken up for in the case. He would be hearing of the disputes from one side of the employer side and other from the employee side also, and he would be noting out the points under the disputes. And after that, he would be arriving at the conclusion, and he will ask for the settlement if they are interested. If the settlement is, if the parties are interested for going for settlement, then he will give the judgment. In case if they are not interested for the settlement, he will write his noting and proceed to the further proceedings that it may go into the court of law, that may be for the labor court for the further dispute resolution. So definition of settlement: the ultimate remedy of a settlement of an industrial dispute is it reference to the adjudication by the labor court or the tribunal when the conciliation machinery fails to bring about a settlement. What does it mean? That when the conciliation officer is been satisfied there is a dispute which is there in the matter and there is no parties are in the modes of settlement, then he will note it and proceed further. Adjudication consists of settling the disputes through intervention by the third party appointed by the government. What does it mean? That the third party, the adjudicator, he would be the person who would be mediating between the dispute between the employee and the workman or the workman and the employer. Settlement is defined under section 2P of the Industrial Dispute Act, which is arrived in the course of conciliation proceedings. That means the party, that is the person who is the officer of the government, he would be hearing the disputes between the employee and the employer. And after he feels that he would be giving the judgment, he will ask the employer as well as the employee to arrive at the settlement. And whatever the settlement terms are there, they would be noted and he would be giving it to the employee and the employer. The agreement between the employer and the workman arrives at the otherwise than in the course of conciliation proceedings. So he may ask the employer or the employee to start with the settlement process. Under the dispute under the Industrial Dispute Act, there would be conciliation. It may consist of work committee followed with conciliation officer and would be board of conciliation. Under the arbitration, it would be court of inquiry. The arbitrator is a third person would be hearing the disputes, and in case of adjudication, it would be labor court. You would be interpreting the law. You would be asking the dispute to be settled between the employer and the employer. Maybe industrial tribunal where there is a dispute related to industries, or would be national tribunal where the disputes are within the boundaries of India. The act provides elaborative and effective machinery to bring about the industrial peace, setting up the various authorities for the investigation and the settlements of the industrial disputes. The various machineries are Works Committee, which is defined under section 3 of the Industrial Dispute Act, Conciliation Officer, which is defined under section 4, Board of Conciliation under section 5, Courts of Inquiry under section 6, Labor Court under section 7, section 7A disputes under the Industrial Tribunal, and section 7B would be in National Tribunal, which are defined under the Industrial Dispute Act. Now coming out to the Works Committee, if you see the conciliation, under the conciliation would be Works Committee. The Works Committee means and committee which is formed within the establishment to solve or for the dispute resolution within the company itself or within the factory itself. The act encourages, the act means Industrial Dispute Act encourages voluntary settlement of the disputes of the Works Committee, whose object is to remove the cause of the friction between the employee and employer Students, you are aware when there is a organization, there would be always a dispute because there is a difference of opinion between the two different persons, hence may arise with the dispute. In case also the needs and wants of the employee is been not certified by the employer, then there would be also a dispute. So day in and day out would be disputes which is going on and on in the companies or the factories. In case of industrial establishment in which 100 and more workmen are working and have been employed in any day preceding 12 months, the appropriate government may appoint a works committee. So mandatory condition for the appointment of work committee is 100 or more than 100 employee. What are the powers and the duties of the works committee? It shall be the duty of the works committee to promote measures of securing and preserving the amity and the good relationship between the employer and the employee, comment upon the matters of their common interest or the concern. So there should be the interest which is common or benefit for all the workers of the factory or the establishment or of the company. So in this case, the work committee has to look for in the betterment of the company as well as for the betterment of the employee also. Coming to the conciliation officer, the conciliation officer is a person who tries to hear the dispute between them, ask them to resolve the dispute, go for the settlement, and after the settlement is there, he would be writing out what are the discussion, what was the positive point of the workers, what are the positive point of the employees, and the negative points of both of them. Then he would be arriving with the conclusion, asking them to come for the settlement process. The appropriate government may by notification in the official gazette may appoint a number of persons as it thinks fit for the conciliation officers. The duty of the conciliation officer shall be mediate in and promote the settlement of industrial dispute. So he is the person, he is called the mediator. He would be hearing about the dispute between the employee and employer. Coming to the duties of the conciliation officer is to hold the conciliation proceedings, to investigate the dispute, to send the report of the memorandum of the settlement to the appropriate government, to send the full report to the appropriate government, setting forth the step taken by him in case of the settlement is been arrived. Coming to the board of conciliation, who are the persons who are sitting in the conciliation board are the board which has been appointed by the appropriate government. The board consists of chairman and 4 other members as the appropriate government thinks fit. Here what do you mean by the appropriate government? It may be the state government, or in case of state government, in case of industrial tribunal, or the national, in case of national tribunal would be the appropriate government would be the central government. The chairman shall be an independent person which has been appointed by the government or by the state government or the central government. What are the disputes which have been referred? Where the appropriate government is it of the opinion that the industrial dispute exists or it is apprehended. What do you mean by exist? There is a dispute which is going on and on. For the betterment of the peace between the employer and employer, the dispute should be settled. So there should be a dispute. And second thing is that the conciliation officer should feel that the dispute may be apprehended and which may cause the loss of the organization. So he may at any time he may order by oral or in writing and refer the dispute to the board of conciliation if he is if he feels that the matter is grave and it cannot be done by him alone. He would be referring this particular matter to the board of conciliation for the settlement thereof. So power of the duties, the power of the conciliation officer, he can enter into the premises without informing them, or he may have the power of the civil court. Coming to the courts of inquiry, the court of inquiry, the appropriate government may by notification in the official gazette constitute a court or into the inquiry of the matters appearing to be connected with or relevant of the industrial disputes. A court may consist of one independent person or may be independent person as the appropriate government thinks fit. Where the court consists of 2 or more persons, one of them may be appointed as a chairman. The references, what are the references to be heard in the court of inquiry? The appropriate government is of the opinion that any dispute exists or apprehended, it may anytime by order in writing refer the matters appearing to be connected with to the relevant of the dispute of the court of inquiry. The next step is the labor code, which is defined under section 7, section 11 and section 15 of the Industrial Dispute Act. The appropriate government by notification the official gazette constitute one or more labor court in the particular district or the taluka or the particular state, as per the number of industries, or as per the government thinks fit that the labor court is to be established, because the number of industries are increasing, and if the number of industries are increasing 100%, there would be a dispute and the matters would be going into the court. Maybe the cases of provident fund or the gratuity, or maybe the cases of the harassment done by the employees or the employers, or maybe dispute related to overtime or not payment of the salary on time, or the ways in which the overtime is not being paid. So in such cases, such type of hearings are being heard into the labor court. In labor court, it would be the employee, he can go directly and enter, and he can appear his case himself without taking the help of the lawyer. So in family court as well as in the labor court, no need of taking the help of the lawyer. So adjudication of the industrial dispute relating to the matters specified in the second schedule, whatever the matters are referred in the second schedules of the Industrial Dispute Act, only that particular matters will be heard by the labor court, performing any other such function as may be assigned under the act. So if the government feels like this particular matters has to be heard by the labor court, then the labor court has to hear these matters. Discharge or dismissal, if there is a person has been discharged from the services, if you see in that particular lockdown, many people has been removed from the services due to the lockdown. So if the government feels like, if the labor court feels that there is an injustice done to the person employee, then then the government will ask them that this particular labor court should hear the dispute. So if there is a dismissal of the workman, if the workman is wrongfully dismissed from the service, then also the labor court intervene into the matter, and he can give the justice to the worker, and the labor court may order for reinstatement with the back wages. So whenever the dispute is going on in the court of law, and when the judgment is been given, the judgment would be backdated from the date of his termination, or from the retrenchment, or from the layout. That particular days onwards, he would be asked that the labor court may ask the employer to pay him with the back wages, or may ask for the grant or relief in case of injustice is been done, or for the wrongful dismissal of the workman. So if there is a withdrawal of any customary concession or the privilege which is there in that particular state, or in the union territories, or in that particular taluka, if the customary traditions have been prevailing in that particular area, and if the industry denies that particular benefits, such cases also may be heard in the labor court. Now coming into the industrial tribunal, which is defined under section 7A of the Industrial Dispute Act. Industrial tribunals is a judicial body, or at any rate, or a quasi-judicial body. Quasi-judicial body means a semi-judicial body. He may have the powers of the court. The appropriate government, by notification, the official gazette, may appoint as many as industrial tribunal as it thinks fit, if the number of industries are more than in that particular state, or in that particular taluka, or that particular region. The industrial tribunal may have same power vested as the power of civil court or the court when trying there is a suit. Suit means the case between the employees or employer, or between the industries or the industries, enforcing the attendance of any person and examining him an oath. What do you mean by enforcing the attendance? He may summon the employer or employee to be present in the court when the disputes are going on, or he may examine him an oath. That means he would be asking him to take on the oath that whatever the statement he is saying is true, maybe in the form of affidavit also. Compelling the production of the documents and the materials of the object. Suppose if the employer doesn't pay the contribution of the provident fund or the gratuity, and he tells to that workers or the employee that his amount which has been deducted is paying to the government organization or to the fund, but he is not paying. In such cases also, he may ask, the industrial tribunal may ask to produce the documents which will be checked and audited by the government. Issuing commissions of the examination of the witness and such other matters prescribed. In such a case, he may ask, the industrial tribunal may ask for the examination of the witness. They may ask the witness to be present in the court of law. And after hearing the disputes or the oral agreement and the written argument, the court may arrive at the conclusion, and he may award whatever the court feels like that award would be awarded to the employee. Coming to the last part, that is the National Tribunal, which is referred under section 7B of the Industrial Dispute Act. Same, that is by the central government official notification may appoint a national tribunal. So if you see that the word national tribunal, there would be maybe only one national tribunal in India, and maybe his office located in Delhi. A national tribunal may consist of one person, may be appointed by the central government. qualification is the presiding officer of the national tribunal. A person may have at least have the qualification of the judge of high court, or may have an office held as a chairman of the member of the labor appellate tribunal for at least 2 years. So he should be either judge of high court, or he should have a member of the labor appellate body for at least 2 years. The central government may appoint 2 assessors to advise to the national tribunal in the proceedings if the matter is new into the particular court of law. No person shall be appointed to continue the office of the presiding officer of the labor court, tribunal or national tribunal if he is not an independent person. If he is connected with the many companies, and then he won't be sitting into the national tribunal, or he may attain the age of 65 years. So the deadline for the age of the age of maturity for the persons who are there in the national tribunal should be less than 65 years. So if you conclude here that the both internal and external bodies have been present to solve the dispute between the employee and the employer, and the unfair labor practices which is done by the employer would be also coming down when it goes into the court of law to robust the internal mechanism that addresses the dispute. So students, under the module 1 I tried to explain in a better way related to the settlement of the dispute and which are the machineries involved into it. Thank you from my side.